College of Commerce, Pune. Sir has completed BSc, LLB, LLM, MA in Sociology, Political Science, History, Economics, Philosophy, MPhil in Commerce, GDC and A, DHL, DCPL, PGDM and IR, and PhD in Business Law. Also, he has completed SET and NET in Law. Sir has experience of teaching since last 30 years, and sir has practiced for 2 years at Pune District Court, and after that since last 28 years he is teaching business law and other related subjects to BCom, MCom, MBA, MPM, PGDBM, MMS, ICWA, LLB, DTL, DLL and LW PGDAB courses of Pune University in various colleges such as Symbiosis Law College, Sinhagad Institute, BMCC, St. Vincent College, Bharati Vidyapit, Naval Wadia Institute of Management Studies and Research, Pune, and Nes Wadia College of Commerce, Pune. Sir stood 6th in University of Pune in LLB exam in the year 1987 and stood 4th in LLM exam in the year 1991. Sir stood 1st in Tilak Maharashtra Vidyapit Pune in MA History. Sir stood 1st in ILS Pune in DCPLE exam held in 2002 with 82%. And sir was University Representative of Law Department in the year 1991. And sir has received Government Open Merit Scholarship for LLB and LLM courses. Sir has written number of articles in journals, papers, books, articles, etc. in various books on legal topics. Sir has received number of awards such as Best Teacher Award, from Vishesh Gunwant Shikshak Puraskar, which is state level, conferred by Sri B.N. Deshmukh at the hands of Justice B.N. Deshmukh sir. Also, he has received Best Teacher Award from Uttar Bharatiya Sangh for his contribution to academic work. Also, he has received honored by Pune Municipal Corporation for his work in social field, and he has received Shikshak Gaurav Puraskar in the year 2015 from Pune Municipal Corporation. The list of achievements of sir is very much long, but this is brief introduction of sir about his career. Now I request Honorable Sir to commence with his speech on Contract Act. Sir, please unmute yourself. Yes.
Good evening, everybody. And thank you very much for my introduction in this particular platform. I'm very happy to share certain views on law of contract today. And we are going to discuss the basics of the law of contract from sections 2 to 75 as such.
Sir, you have been muted. Please. Sorry. Yes.
Yeah, I think yes. So, first of all, I would like to appreciate the efforts of the Bar Council of Maharashtra and Goa to have such type of a series of lectures for the benefit of those who are appearing for the judicial examinations as such. One of the very important topics in the mains exams is law of contract. And I am assigned the task to discuss with you right from section 2 onwards to 75 as such. All these sections talk about very fundamental aspects of contract. As all of us are well aware, and all of us have studied law of contract right from the beginning when we started our career as a law student. And therefore, when we come across the very fundamental provisions of law of contract, we learned a lot and we found that, yes, something in day-to-day life, we do enter into various kinds of transactions, knowingly and unknowingly, even sometimes without knowing its legality or the nature of its legal framework as such. Sometimes we go to a hotel, order a cup of tea, and we don't know that we have entered into a contract. We are going through we are boarding a bus, we are going through auto rickshaw, we are purchasing goods in the shopkeeper or even hawkers on the street. We are purchasing apples from him without knowing that we are actually entering into a valid legal contract, because we have not given a thought on that. However, after starting study of law, we understood that all these transactions have got an importance from the legal point of view. And therefore, law of contract is unique in the sense that if you see all other laws, every law talks about certain rights and obligations, rights and duties. And when you get certain rights under a particular law, then you try to vindicate those rights by exercising the provisions of law. Therefore, rights and duties or rights and obligations are the creation of some particular law. Law of contract is different than these laws in one sense of the term, that this law of contract does not create rights and obligations by itself, but they will lay down the principles within which the parties can themselves decide and determine their rights and obligations. You will ask how? This is possible because the legal framework has been given by law. Indian Contract Act 1872, the legislation will be completing 150 years after 6 months. And you will find that by and large, there are no amendments in the Indian Contract Act. I'm saying by and large, I'm saying because it's 150 years is a very large span of time where the way of thinking, way of life, technology, everything has been drastically changed and evolved. Despite this fact, the provisions of law of contracts are in a position to tackle the 21st century and new upcoming challenges coming through whatever right now, online transactions, online contracts, e-contracts, all of them can very well be fitting into the domain of law of contract even today. With certain amendments here and there in other laws, they are there. But basically what I want to emphasize at this particular point of time is this, that after 150 years also, the law is dynamic, law is evolving, and law is taking care of its dynamism by very much having its applicability even today in the changing scenario as such. Therefore, I made a statement that law of contract is different than other laws because this law is not creating rights and obligations amongst the parties, but the contracting parties themselves create rights and obligations amongst them by entering into a contract. When I say now entering into a contract, we have to understand the journey of formation of a contract. Many times we do use the terms agreements and contracts interchangeably in day-to-day life. However, when we talk about law of contract, and once we started thinking about the Indian Contract Act 1872, we cannot use these terms interchangeably. And therefore, you will find, even if you see, if I have to define section 2 of this particular Indian Contract Act, and as you know that most of the section 2 in the legislations will be talking about the interpretation clause or definitions. The terms, various terms and terminologies which are used in the body of text of the law are tried to be defined in section 2 by and large. not necessarily section 2, but we have witnessed that in most of the section 2, we'll be discussing about that. Section 1 will be generally talking about the objectives or the applicability of the Act as such, as same is the case with Indian Contract Act also. Therefore, you will find that contract itself is defined in section 2 subclause H of the Act. And it says contract is an agreement enforceable by law. Now, these are the terms which we have to understand now. Okay, so now, in short, contract is equal to agreement plus enforceable by law. When I say enforceable by law, that means it's an agreement which is backed by legal sanction. This is an agreement which can be implemented, which can be executed with the help of law. And if that agreement is having capacity and capability of getting enforced with the provisions of law, then only that agreement will become a contract. Now, each and every term is tried to be defined. And if you see that when I say about even agreement, that agreement is also tried to be defined in this case. And therefore, section 2 subclause E will be also defining the agreement as such. How agreement has been defined? And it says agreement is nothing but a promise. Agreement is nothing but a promise. So agreement is equal to promise, right? Or the set of promises forming consideration to each other. So this is the definition of agreement. Now, generally what we say, no, what is agreement? Oh, agreement is a deal between two parties. Agreement is a transaction between two parties. Agreement is nothing but two parties are coming together and agreeing upon certain things. Yes, you're right. But now, when we talk about the aspect in the eyes of law, then we have to follow the legal provisions and we have to identify the terminology on the basis of definition. And therefore, you will find now that it defines that agreement is a promise. It's simple words. So therefore, agreement is a promise. Now, what is promise? Again, we have to go back to the law and find out what is promise. But right now, I'm trying to define the entire term agreement, and that is agreement is a promise or a set of promises. That means there are more than one promise. It's a set of promises. And these promises could be a consideration to each other. They are forming consideration to each other. It means, suppose there could be a one promise which you are giving it to me, and I'm giving you another promise. I agreed, or rather I said that I promised to sell my bike, say Pulsar bike, to you for 50,000 rupees. And you said, okay, sir, I promise to pay you 50,000 rupees as a price of your Pulsar bike. So you are giving me one promise of paying the price, and I'm giving you a promise to sell my bike. So these are the two promises. And these two promises are forming consideration to each other. Again, the definition of consideration will have to be done. Right now, keep in mind that consideration is nothing but something in return. Consideration is nothing but the price paid by one person to purchase the promise of another. So if you are going to sell your flat to me for 1 crore, I am giving you 1 crore. 1 crore is the price which I am paying. 1 crore is the consideration which I am giving it to you, because you are also giving me another promise to sell your flat. Anyway, coming back to the definition of agreement, it's a promise or set of promises forming consideration to each other. I have discussed the forming consideration to each other, but I have, in a brief, you can keep in mind that agreement is a promise. Now, what is promise? Promise is also defined. Promise is defined in section 2 subclause B. And what is that? It says it is nothing but an acceptance of a proposal. A person to whom, rather, it says that proposal, when accepted, becomes a promise. So that means somebody should make a proposal, and the other person to whom proposal has been made gives his consent thereto. Then we say that proposal is accepted, okay? And that accepted proposal is nothing but a promise. Okay, so when I say, will you purchase my car for 4 lakhs rupees? And if you say yes, so it means you have accepted my proposal. And that acceptance of a proposal itself is a promise. Okay, and promise is an agreement. And if that agreement is enforceable by law, executable by law, implementable by law, it becomes a contract, and then only the contract will be in a position to, Contract Act will be in a position to help you out. Therefore, in short now, when I say promise is nothing but accepted proposal. In short, promise is equal to, now it's like a mathematical formula. Contract is equal to an agreement, which plus enforceability by law. Agreement is a promise. Promise is equal to proposal plus acceptance. Okay. And then we can say that yes, promise is an accepted proposal. And if that promise or if that agreement has backing of law, that is law of contract, okay, if it is legal, if it is justified, if it is fulfilling all necessary prerequisites of Indian Contract Act, then only that agreement becomes a contract. Okay. Now, I have in the due course of time, I also said that it is a consideration, nudum pactum, that is any agreement, naked promise is of no use. Law expects that if you want legal sanctity to any agreement, then both the parties must give something in return to others. So if I say that I promise to pay 1 lakh rupees to all participants who are listening my lecture today, and in return, you are not giving me anything. So I am giving you a promise, and in return, you are not giving me anything in return. You are not paying the price for that. You are not exchanging anything. So my promise is one-sided promise, and it is not supported by consideration. It is not supported by price. Then that price, this promise or this pact or this agreement is without consideration, and it will not be enforceable by law. And finally, this agreement will not become a contract. Okay. So therefore, but now just offer and acceptance will become a contract. But at the same time, as I said, a mayor, if I call you for a party, my birthday party in the evening, and I said, will you come for my party, birthday celebrations? And you said, yes. And in the evening, you did not come. And I had to pay for my hotel wala the entire cost. Tomorrow, I filed case against you to recover the damages or recover the compensation because I suffered because of your breach of contract, because you promised to come to attend my birthday party, did not come, and I had to suffer a loss. So will that be possible? Then law says it will not be possible for a simple reason that it was a social contract. It was not a legal contract. It was not backed by consideration. You have never agreed to pay me something in return. You would say, no, no, sir, we were planning to say thank you. Thank you doesn't have value in the eyes of law. And therefore, such kind of agreements, though we feel that they are agreements. I said, will you come for the party? You said, yes. So I have made you an offer. You have accepted it. However, it is not supported by any price. And in such circumstances, such type of agreement remains agreement. It becomes a social agreement. It becomes a social contract. It will never become a legal contract, or it will never be converted into a contract. Therefore, at this particular point of time, you will understand that I will jump now, because now you have understood that all the agreement will become contract only when it is backed by legal provisions. Agreement will become contract only if it is enforceable by law. Now, nowhere in the Indian Contract Act, the definition of enforceability has been given. We have to find out from various other provisions. And we get clue or cue from section 10 of Indian Contract Act. And this section 10 is very interesting. And section 10 says that all contracts are agreements. Section 10 says all contracts are agreements if they are made by free consent of the parties competent to contract with lawful object and lawful consideration. And if such agreements are not expressly declared by law to be void, okay, then only such contracts are agreements. Such agreements are contracts. I will repeat. Now, section 10 is very, very important to understand the legality of agreement. Okay, and it says all contracts are agreements. Correct. All contracts are agreements because If that agreement is enforceable by law, then it becomes contract. But enforceability by law का definition नहीं दिया है. Therefore, then we have to read section 10. What section 10 says? All agreements are contract. Sorry, all contracts are agreement if they are made by free consent of the parties. Therefore, number one point, that if you want this agreement to become a contract, there must be free consent of the parties. So number one essential elements required for valid contract is free consent of the parties. What type of a parties? Which parties? Naturally, answer is contracting parties. Okay. Now this, what kind of a, when these contracting parties become eligible to enter into a contract? Yes, nobody can become eligible to enter into a contract. You will become eligible to enter into a contract provided you have that capacity to enter into a contract. You are a competent person to enter into a contract. And how that capacity is mentioned? Then they say that by free consent of the parties competent to contract. Okay, so that means you must be competent. Who is going to decide you are competent? Again, law is going to decide whether you are competent or not. Okay, and therefore, when you become competent, in another definition, they have mentioned that when you become competent to enter into a contract. Okay, you become competent to enter into a contract, or you get capacity to enter into a contract if you attain the age of majority, if you have a sound mind, and if you are not disqualified by law from contract, then you become competent. Okay, in brief, so I will be discussing all these points in detail in due course of discussion. But at this particular point of time, I would like to attract your attention to the fact that agreement will become a contract if it is enforceable by law. And section 10 says there must be a free consent. Whose free consent? Competent parties free consent. Who is competent? Just now I discussed. Now, this agreement must have been entered into with lawful object and lawful consideration. So I told you what is consideration. Consideration is price paid, whatever you are exchanging. Okay, so you have to take into consideration that the consideration, the price which you have to pay is the consideration. But this consideration is also required to be lawful. Okay. Now I will discuss this lawful consideration aspect a little bit later. But at this point of time, let us say that there must be a competent parties, there must be free consent of the parties, there must be consideration. Consideration must be a lawful, and not only consideration is lawful, but lawful consideration and lawful object. That is what section 10 says. Therefore, there must be lawful object of your agreement. Okay, that means whatever you are exchanging is also required to be lawful. Consideration should also be lawful. So if I agreed to sell my car to you for half kg ganja or charas or brown sugar, will that be valid? The answer comes no, it is not valid. Why? Charas, ganja, afu, all the opium, these are not the substances which can be considered as a valid substances. They cannot be purchased, they cannot be sold, and they are not permitted. It is illegal, and therefore such type of a consideration is not permissible. So my point is, therefore, whatever price you are paying must be a valid price. Consideration must be lawful. It should not be unlawful. Okay, object, ultimate object of your contract should also be lawful. So if I'm collecting, I'm collecting funds, and why these particular funds are being collected, I asked, you pay me 100 rupees each participants, and if suppose there are 200 participants, I will get so and so amount of amount, and then this amount will be used to threaten the bank officer, and to get more amount, we will be getting by giving him some kind of a threats, and we will hire a particular person, and then we will go about it. Okay, so this kind of a transaction will not be permissible because object is unlawful. Or if we are trying to give supari to gundas and we say, no, no, we will pay you 2 lakhs rupees and go and have a dacoity on a bank, and then whatever you are going to get, we will be sharing the amount which you are bringing back from the banks. Okay, will that be permissible? It will not be permissible because the object of this deal is itself unlawful as such. Okay, so therefore, I am trying to discuss here that contract becomes contract provided there is free consent of the parties, there is proposal, there is acceptance, there is concession, there is lawful concession, there is lawful object. Okay, all these things are required to be there. And one more thing, which the judiciary has decided, that whatever you agreed, जो भी contract आपने बनाया है, it should be in a position to be enforced. It should be a possible thing. Tomorrow, if I say that if you give me 10 lakhs rupees, I will convert this watch into a golden watch. If this is what it is there, so I cannot convert this normal metal watch into a golden watch, because that would become a magic, and there is no chemical formula with me. So if I say something like this, it is not possible. Or if I say, if you give me 1 lakh rupees, I will jump from ground floor to the 5th floor of the building, which is impossible. Even if I give a proposal, you accepted it, everything is fine, still the act which you agreed to perform, contract which you agreed to perform, cannot be performed. It is not possible to perform it. Okay, if I agreed, a typical example given in the textbook is, if you bring 2 parallel lines together, I will promise to be so and so. Never possible, because with the moment we say they are parallel, it means they will never meet each other till the infinity, right? Now, one more thing which section 10 talks about, moreover, if any law requires certain legal formalities to be completed, then those legal formalities must be completed. Now, what are those legal formalities? These legal formalities are nothing but, sometimes, the Registration Act, section 17, 18, they talk about what are the documents to be required, compulsorily required to be registered. Now, for example, selling and purchasing of a land must be registered, must be on some kind of a stamp paper, must be in the presence of witnesses. All these things are required because there are independent legislations which have compelled all of us to register the document, must be executed on the requisite stamp paper, and it must be executed in the presence of witnesses, and then only that agreement, that contract, that sale deed, that deed of assignment, or the whatever is you may call it is, will become a valid one. Okay, and therefore, if law is compelling us to have such type of an agreement by completing legal formalities like stamp duty, written document, and in the presence of certain witnesses, then such type of a legal compulsorily prerequisites must be followed by the parties if you want that agreement to become enforceable by law, or that agreement to get the status of law of contract. So this is important. Therefore, now on this particular basis, if all these elements are there in a contract, then only, or in the agreement, then this agreement becomes a contract. Now, all these points I will have probably discussed gradually, and I will be discussed in due course of a time, that like what is proposal. So that means agreement is nothing but a promise. Promise is nothing but a proposal plus acceptance. There must be free consent of the parties. All these ingredients which I have just discussed in brief, they are must. Agreement plus all these things is equal to contract. That means all these things are nothing but the prerequisites to make your agreement executable in the eyes of law. Okay, so if you want to make your agreement enforceable or executable or implementable by law, then all these necessary essential elements are required for making it a valid contract. Therefore, I tried to find out the question papers which have been past question papers asked in these judicial examinations. In one of the examinations, they had asked a quote that all contracts are agreements, but all agreements are not necessarily contracts. Or all contracts are agreements, but all agreements are not contract. Discuss in the light of legal provisions of Indian contract. Such type of question is likely to be asked. If this question is asked, then you have to start from the definition of a contract, explain the agreement, then agreement is a promise, then enforceability, then come to the section 10, till when agreement becomes enforceable, then you will have to say that all agreements, all contracts are agreements if they are made by free consent of the parties. Write free consent in brief. Competent parties discuss in brief. Discuss about consideration. Discuss about lawful consideration, lawful object. Okay. And then you will have to that they are not expressly declared by law to be void. There are certain sections in our contract which have categorically mentioned that certain agreements to be void. Okay, now I'm using a term void. Agreement is expressly declared by law to be void. और void का word जो है उसका भी definition दिया है, त्याची पण व्याख्या दिलेली आहे आणि त्या व्याख्येमध्ये त्यांनी सांगितले की what is void? Void is not enforceable by law. So agreement which is enforceable by law is a valid agreement, is a valid contract. An agreement which is not enforceable by law will become void agreement. Okay, so void agreement will never become a valid agreement. Okay, because the moment I use the term void agreement, that means that agreement is not fulfilling all those essential elements required under section 10 of the Indian Contract Act. This fact we have to keep in mind. Okay, therefore, void agreement is void agreement. It will not become valid agreement. Okay, and agreement will become valid or valid contract only when it fulfills all those necessary elements which I have discussed just now. Therefore, whenever now I am making a reference, and all of us, whenever we use the term contract, we have to presume that it is a valid contract. We have to presume that the moment I utter a word contract means it has fulfilled all necessary elements mentioned in section 10. Then only it becomes a contract. Then only it becomes a valid contract. And if agreement is not fulfilling those terms mentioned in section 10, it remains a void contract, void agreement. Okay. Now, I will be discussing certain terminologies because sometimes we get confused at the time of examination. Sometimes they would ask you what are the different types of contracts. Okay. Now, when we talk about types of contracts, we will have to find out that how they are classified. They are classified from various angles, from the basically how the contract is being formed. Depending upon that, also classification could be made. One of them is implied contract. That means contract did not necessarily be an implied, it may not be necessarily an express contract. And therefore, you will find that implied contract is nothing but the contract which will happen through conduct of the parties. Okay, and therefore you will have to see that how this conduct of the parties. As I said, that if you are going on the road and board a rickshaw, rickshawala is going, and you just made a hand to him. He stopped the rickshaw. You occupied the bus, and then he started going ahead. You did not speak anything, and at a particular place you said stop, 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 and then you are getting outside of the rickshaw. And rickshaw says, pay the price. Will you say, no, no, sorry, it was not decided. There was no proposal, no acceptance, no price, nothing has been formed. Rickshawala is not giving this particular service free of cost. Okay, so it is through conduct of the parties also. Okay, therefore, you will find that sometimes the agreement will be entered into through conduct of the parties, implied contract. Okay, when you go to a restaurant, there are two, you are going with a friend, and when you occupy a seat in the restaurant, you said just, and the fellow brought 2 cups of tea. You consumed a tea, and while going back, you are not paying the the bill. The restaurant wala would say, no, no, you have to pay the bill. So is it not a contract? You would say, no, no, proposal kahan hai, legal agreement kahan hai, writing mein kahan hai, stamp paper mein kahan hai, jarurat hai kya? Jarurat bilkul nahi hai, because Indian contract is not compelling you to have your every agreement in written form. There could be many more agreements which are oral agreements, and oral agreements are perfectly all right unless and until law compels you to reduce it in writing. Okay. Express contract hai, so it is expressly the parties have expressed them very specifically either by words spoken or written. Okay. आप दूसरे के साथ बात करते हो और बात करते करते आपने कॉन्ट्रैक्ट किया है. जैसे कि आप मार्केट में जाते हो, बोलते कि कैसे दिए एप्पल्स, तो बंदे ने बोला कि नहीं सर 50 रुपए को आधा किलो हम देते हैं. ओके ठीक है, आधा किलो दे दो, तो आपको 50 रुपए देना पड़ेगा. सो ये आपका ओरल एग्रीमेंट है, एंड ओरल एग्रीमेंट इज ऑल्सो परफेक्टली वैलिड because nowhere law says that when you are going to the mandi and purchasing goods, it must be in the written form. There is no need. And therefore, my point is there could be implied contract which is formed out of your conduct. There could be express contract expressed in terms of words. It may be a spoken, it may be written, and therefore we say this is a classification on the basis of formation of a contract as such. Okay. Sometimes we call it as a unilateral contract. Unilateral contract means one party has performed his part of a contract and other person has not performed his part of contract. It is unilateral contract. Bilateral contract, both the parties have not yet performed their part of a contract. Therefore, we may call it as a bilateral contract as such. When both the parties have performed their part of contract, we say contract is executed, and it is also called as executed contract. If the performance of contract is yet to be executed, or yet our contract is yet to be performed, we do also call it as executory contract. Okay. The other two terminologies on the basis of legality we have discussed, that valid contract, that is which fulfills all prerequisites of section 10. Then I discussed you void agreement, which does not fulfill the expectations of section 10. Then there is one terminology called as void contract. It has been given in. I will not quote all sections, but when you are going back and trying to read the bare act, you will understand whatever I am discussing is somewhere reflected in these sections. I am not going section wise. I am trying to make some conceptual clarity so that when you go back and try to read the any book, or when you go back and try to read the actual sections in the bare text, then you can relate the discussion which we are having right now. Okay, and there are certain things which are very categorically defined in the Indian Contract Act also. Now there is one term, probably we may call it as a void contract. Void term जो है वो void, तो हमने बोला कि void is nothing but not enforceable by law, और contract का मतलब है agreement enforceable by law. तो void contract का meaning क्या है? So that becomes difficult. If some of you are comfortable, you can also answer in the chat box. I don't know whether I have access for the chat box, but if you feel like void contract का मतलब क्या है? Okay, I am giving you meaning of both the terms. Contract का मतलब है agreement which is enforceable by law, और void का मतलब है not enforceable by law. तो collectively void contract का मतलब क्या है? If you feel like you can write in the chat box. Till then, I will go a little bit ahead and we'll come back to void contract. If you are not answering the chat box, then I will explain you even that whatever is there. Okay. Then there is one category whereby we can say that it's an unenforceable contract. Okay, unenforceable contract. Now, what is unenforceable contract? Contract which is not basically enforceable, which cannot be executed. Okay, yes, somebody has mentioned that, okay, earlier it was valid, but now it becomes void. Perfectly all right. So it means, see, void contract is not a conflicting term, because otherwise void is not enforceable by law and contract is agreement enforceable by law. We cannot say that agreement which is enforceable by law and not enforceable by law. That will become a paradoxical statement or confusing statement. So what somebody has answered it very correctly, that the agreement was initially valid, perfectly valid, section 2J, very true. So when agreement is initially valid, something happens. So at the time of formation of a contract, it was perfectly all right. But at the time of execution, in between, something had occurred wherein the performance of contract becomes impossible. For example, I agreed to sell my bike to you in the next week for 50,000 rupees. And today the bike is there, but tomorrow because of some accident, my bike is smashed. It is not exist. It is absolutely destroyed. So when I say it at the time of performance in the next week, I don't have a right bike with me to give you. And therefore, though today the contract is valid, tomorrow after a week, it becomes a void contract, because though contract was initially valid, on the date of performance, it would not be possible to get it enforced, and therefore it would become a void contract. Similarly, we will find illegal contracts. Okay, the contract is valid today, but tomorrow some new law will come. Yeah, formal agreement that is effectively illegitimate and unenforceable. Okay, fine, right. So therefore, if I go a little bit ahead, that illegal contract, again, the contract which was initially valid, and after the performance, the thing which you agreed for becomes illegal. New law comes into picture, and law says, no, this transaction cannot be done. If it is said that, no, you cannot sell bike to any lawyer, okay, or selling a bike by any teacher from the college to any lawyer in the court is illegal. Suppose that new law has been passed. Okay, so that what we say, that initially contract was valid, but afterwards it has become illegal because the new law has come into effect, and therefore we can probably define such type of a classification on the basis of such type of a circumstance. There is one more term called as voidable contract. Okay, now voidable contract, for the sake of understanding, keep in mind that it is voidable is nothing but, not a very good way of explaining, but it is avoidable. Okay, and voidable contract is a contract which can be avoided by one of the contracting parties, probably, whose consent is not free. Okay, I will discuss this when I'm going to discuss with the free consent aspect of free consent as such. So at this particular point of time, you just keep in mind, voidable contract is a contract which is avoidable by one of the parties. That means one party can, avoid its performance, or one party gets option to make it either valid or void. If he decides, I don't want to go ahead with the contract, then that becomes a void contract. So voidable contract has got potential to continue as a valid contract if party does not object. But if the party does not, if the party does object for that because his consent was not free, then he can exercise his option. ये contract में मेरा consent free नहीं था, इसलिए ये contract voidable है और मुझे avoid करने का है, I don't want to go ahead with that. Then that contract would become a voidable contract as such. So this is what we have to discuss about the classification of contract on the basis of either execution, on the basis of legality as such. Okay, now I will be discussing in brief how the journey of a contract goes ahead. I told you that for the purpose of forming an agreement, you have to have accepted proposal, that means proposal and acceptance. Okay, what is proposal? Proposal defined in section 2 subclause A of the Act. And section 2 subclause A of the Act defines the term proposal. Now you know, when I say, will you purchase this watch for 500 rupees? Okay, when I say this, yes, I have made the proposal, right? But what is how it has been defined? When we say, when one person signifies his willingness to another with a view to obtaining the assent of that other, then we say that this person, he is said to make a proposal. So proposal mein kya hai? There must be expression of willingness to do something or not to do something. Such type of expression of willingness, if it is communicated to the other, if it is signified to the other person, and the objective of making such type of a expression of a statement is with a view to obtaining your consent. So when I say, would you like to purchase my bike for 50,000 rupees? That means I want you to say yes. I want your consent. I am expressing my willingness to sell my bike. If I say, if you don't park your vehicle on so and so place, and if, then I promise to give you so and so amount. That means I want you not to park your vehicle at a particular place, whereby I can park my vehicle at that particular place, and therefore I promise to pay you some amount. in such circumstances that is possible. Okay. Yeah, I will come to that. I will also discuss voidable contract when I discuss a free consent little bit later. Okay. So therefore, right now I'm going with a journey. Like the first station in the journey of contract is an offer, or offer is the word which has been used in English law of contract. Proposal is the word which has been used in Indian Contract Act. Okay. So I have discussed with you the definition of proposal, where it says when one person signifies his willingness, okay, to do or abstain from doing something with a view to obtaining the assent or consent of the other person, then one person is said to make a proposal to the other person. Okay. Now this proposal can also be expressed. Proposal can also be implied. Proposal can also be through conduct of the parties. Proposal may be made to the public at large, which is called a general proposal. Proposal may be made to a specific individual, a person, Mr. Ganesh. Then it is a specific proposal. So there could be a general proposal when it is made to the general proposal to the general public at large. It may be expressed, it may be implied. There could be a counter proposal. So when I say, would you like to purchase my bike for 50,000 rupees? And you said, sir, will you sell it for 40,000? Or I will purchase it for 40,000 rupees. Actual, when I say, will you purchase my bike for 50,000 rupees? You are saying, okay, purchase your bike for 40,000 rupees. So you are not accepting my proposal, but you are making counter proposal indirectly by saying that, sir, would you like to sell your bike to me for 40,000 rupees? It's what we call it as a counter proposal. Or I would say, okay, my offer is open, standing offer. Anybody who would like to come, I have a 10 bikes and 50,000 is the cost. For this 1 month, all these 10 bikes are for sale. So it's a standing offer for all of you that you can come and accept, because I have given a specific time span that this is 1 year span, and within that you can come at any point of time because it is a standing offer, and you can come and you can say, yes, sir, I wish to purchase so and so bike, and then you can go ahead with that, and you will find that the proposal is there. So you will find such type of things are there. Now there was a case. Now, therefore, proposal, as I said, it must be made for a specific act. It must be for doing some positive act or for not doing something. All these things are there. It must be made to do some certain things as such. The proposal must be made for doing something which is really possible. Okay. And then you will find that similarly, that it must be in unequivocal terms. The language of proposal must be understandable. There must be clarity in the statement which I'm making. Okay, there should not be confusion. There should not be confusion about the statements which I have made in my proposal as such. So that fact is also required to be taken into consideration when we are talking about a legal proposal as such. So that proposal should be a legal. It must be for a possible thing. It must be made to a specific person or general proposal and all that. And it must contain all those particular section 2 subclause A as such. It may be through conduct also. Now, the person to whom proposal has been made signifies his assent. Assent का मतलब है consent. The person to whom proposal has been made, इसका मतलब जिसको मैंने proposal किया है, उसको बोलते हैं promisee. जो proposal करता है, the person who makes the proposal, जो offer करता है, उसको हम बोलते हैं promisor. Okay, these are the definitions given in the Contract Act. The person who makes a proposal is promisor. The person who accepts the proposal is an acceptor. Technically, we call him as a promisee because promisee is the person to whom proposal has been made. Section 2 subclause B talks about the definition of acceptance, and it says the person to whom proposal has been made signifies his assent. Assent का मतलब है consent. Thereto, then we say that proposal has been accepted. Okay, so who has to give acceptance to the proposal? So now I am a promisor, you are a promisee. When I say, would you like to purchase my bike for 50,000 rupees? I am a promisor, you are a promisee. And when promisee gives consent, promisee gives assent to my proposal, then that proposal is said to be accepted. So when I make a proposal, And when you are giving acceptance, acceptance must be given 100%. Acceptance must be full. Acceptance must be absolute and unqualified. Therefore, if you said, no, sir, accepted your bike for 40,000, sorry, it cannot be called as acceptance. It can be called as counter offer. And then it is up to me whether to say yes or no. Okay. So acceptance can be given in the written form. Acceptance can be expressed. Acceptance can be given through conduct of the parties. And there was a very famous case of Carlyle versus Carbolic Smokeball Company. In the Western case, you must be doing almost 101 case. There was a public advertisement in the newspaper whereby they have mentioned that we are the manufacturers of carbolic smokeballs, which is the medicine available on the disease of influenza. And anybody who suffers from influenza, if they consume our medicine, they will be definitely recovered from the influenza. And if you are not recovered from the influenza, we promise to pay so and so amount by way of reward. One Mrs. Carlyle read the advertisement, went to the market, purchased the medicine, consumed the medicines, and could not recover from the disease, and therefore asked for the reward, for which company said no, filed a case in the court of law that I have accepted the proposal, and therefore I must get the compensation, or I'm not recovered. So there was a question: was there a contract? Company said no, there was no contract. Why there was no contract? No, we had given advertisement that anybody consuming the medicine as per the prescription will be certainly recovering from the disease. You are not recovered, but have you given acceptance? Mrs. Carlyle says, I haven't given acceptance by this way. It was a tacit acceptance. The acceptance was through conduct. How it was through conduct? The moment I read the advertisement, I am responding to your advertisement by going to the shop, purchasing the medicine, reading the prescription, reading the directions, and consuming the medicine, and still not recovered. So you cannot. And finally, the court has also declared that it was a general offer made by the carbolic smokeball company to the public at large. It is not rationally correct to expect acceptance of each and every member of the public to go to the company and communicate his acceptance very expressly. And it is okay that through conduct, directly by performing the act which is expected in the proposal, itself can be considered as acceptance of a proposal, and that is that acceptance through conduct of the parties is perfectly all right. That was the verdict given in Carlyle versus Carbolic Smokeball Company, and the lady was granted a compensation. Point is that acceptance should be perfect, absolute, unqualified. You cannot put conditions when acceptance. Okay, if I say no, would you like to purchase my Pulsar bike for 50,000 rupees? You said, okay, sir, accepted your Pulsar bike for 50,000 rupees, provided you give delivery of this Pulsar bike at Mahabaleshwar. See, I am staying in Pune, you are staying in Mumbai, and you are compelling me to go to Mahabaleshwar for giving delivery. It is not understandable. And therefore, you cannot put condition when you are accepting the proposal. It should be absolutely unconditional. You have to follow all those terms and conditions specified by me in the proposal. Sometimes I am likely to specifically mention how my acceptance is required to be given. If I say, send your acceptance to registered post, you have to send it by registered post. If I said, communicate me through WhatsApp, you have communicated your acceptance through WhatsApp, it will be valid. Communicating your acceptance through registered AD post may not be valid when I am insisting you to send your acceptance on WhatsApp only. Promisor has got every right to compel you, and I can dictate the manner and mode in which I am expecting your acceptance. मैं जिस तरीके से acceptance चाहता हूं, वो आपको follow करना पड़ेगा, क्योंकि I am going to dictate those things in my proposal. If I haven't mentioned anything in the proposal, then you can take an option and then you can accept my probably proposal in any other rational and reasonable mode of acceptance. I can specifically mention the time span. that within which you have to give your acceptance. If you don't give your acceptance within a stipulated time, then that acceptance will not be a valid acceptance as such. So my point is, acceptance should also be legal. If the time is mentioned, send your acceptance within time. Mode is mentioned, follow that mode. Okay. And if nothing is mentioned, you must give your acceptance within a reasonable span of time and by reasonable mode of acceptance as such. So all these factors are equally important. If I have given you a proposal, you are a promisee. Promisee has to give acceptance. Somebody from you, unauthorized person, cannot give acceptance. If I made you a proposal, or lawyers who are appearing for judicial examinations, that will you purchase my bike for 50,000 rupees? Somebody colleague from my college comes and says, okay, I heard that you want to sell your bike. I accept your proposal. Sorry, I did not make any proposal to my colleague in my college. I made proposal to you all. You are the only promisee, and promisee can give the acceptance. No other person can give, third party cannot give any kind of a acceptance as such. So my point is, all these rules of proposal and rules of acceptance which are developed by law has to be followed. There are many more case laws, but I will not discuss all this case law because we don't have that much time with us. Okay, so therefore we have to keep in mind all these things. Okay, now there are certain provisions of communication of proposal is important. Similarly, communication of acceptance is also required. Communication of proposal is very simple. The moment the proposal is, when it comes to the knowledge of promisee, my proposal is communicated. Acceptance of communication of acceptance of a communication of acceptance will depend upon certain circumstances. I would request you to read section 456, that when communication of acceptance is complete, and there is a postal rule which is a little bit clumsy, but you have to get it understand. So for example, just for the purpose of understanding, I will little bit discuss and then I will go ahead. Okay, so you are staying in Bombay, and I have sent you made a proposal in this platform that would you like to purchase my Pulsar bike for 50,000 rupees? Communicate your acceptance by registered post or say by post. Now you have written a letter. Okay, Dr. Chaudhari sir, accepted your proposal, that is accepted your bike for 50,000 rupees. Thank you. You posted that letter of acceptance in the post box or in the post office, right? So whether your acceptance is complete, that is a very critical question, because now somebody would say, and you can probably answer in the chat box also, when communication of acceptance is complete. Okay, but now let me tell you that this communication of acceptance is not so simple, and therefore the rule of postal rule comes. When you drop the letter of acceptance in the post box and you lost the control over that particular letter, at that moment, that communication of your acceptance is complete as against the proposer, that means promisor. Okay, and it is binding on me. It may not be binding on you. Okay, आपने जो acceptance दिया है, letter of acceptance आपने post box में डाला, and it is out of your control. That means you cannot take it back. So whatever you were supposed to do, you have done it. Your acceptance is binding on you, because the moment communication of acceptance is complete, the moment promisee signifies his assent thereto, a binding agreement is created, and that agreement is binding on me. Okay, but that your acceptance is probably not binding on you unless and until that letter actually reaches to me. जब तक वो मुझे नहीं पहुंचता है, तब तक वो आपके ऊपर बाइंडिंग नहीं है. ओके, ये आपको याद रखना पड़ेगा. तो आपका एक्सेप्टेंस आपके ऊपर बाइंडिंग तब होगा जब वो लेटर मुझे एक्चुअली मिलेगा. ये इतना ही ख्याल में रखो कि कम्युनिकेशन ऑफ एक्सेप्टेंस विल बी कंप्लीटेड 2 लेवल्स. आपने जब पोस्ट में लेटर डाला, वो मेरे ऊपर बाइंडिंग है, मगर आपके ऊपर बाइंडिंग नहीं है. ओके, और आपका जो एक्सेप्टेंस लेटर मुझे जब मिलता है तो वो आपके ऊपर बाइंडिंग होता है. बाद में आपने बोला कि नहीं सर, मुझे आपका बाइक नहीं चाहिए, तो मैं आपके अगेंस्ट एक्शन ले सकता हूँ. और ये जर्नी में जब योर लेटर ऑफ एक्सेप्टेंस इज इन ट्रांजिट, शायद आप बॉम्बे में हो और बॉम्बे से पुणे में लोनावाला में आपका लेटर पोस्टल व्हीकल में है और वो व्हीकल डिस्ट्रॉय हो गया, सो योर acceptance letter will never reach me. Okay. In such circumstances also, your acceptance is complete against me and binding on me as such. Okay. However, you have every right to withdraw or revoke your letter of acceptance till it reaches to me. Okay. जब तक वो मुझे पहुंचता नहीं है, आपको रिवोक करने का मतलब withdrawing your acceptance is possible. Okay. Maybe मेरा proposal revoke कर सकता, revoking means taking it back, cancelling my proposal. I can revoke or cancel my proposal at any point of time till you send your acceptance. Okay. And that acceptance is not binding on me. Okay. जब तक आप आपका acceptance नहीं देते हो और जब तक वो acceptance मेरे ऊपर binding नहीं होता है, तब तक मुझे मेरा proposal वापस लेने का, revoke करने का अधिकार है. आपके हाथ में आपके लेटर ऑफ एक्सेप्टेंस है, आपने पोस्ट में नहीं डाला है और मुझे मेरा प्रपोजल रिवोक करने का है. आई कैन कॉल यू ऑन फोन एंड आई कैन से हेलो सर, वो जो मैंने आपको बाइक के बारे में प्रपोजल किया था, आई एम रिवोकिंग माय प्रपोजल एंड दैट रिवोकेशन इज वैलिड बिकॉज यू हैव नॉट येट गिवन योर एक्सेप्टेंस टू मी. इट इज नॉट बाइंडिंग ऑन मी. ओके. सो इन सिंपल रीजंस प्रपोजल कैन बी रिवोक्ड, कभी भी रिवोक कर सकते जब तक सामने वाले ने उसका एक्सेप्टेंस भेजा नहीं है. ओके. सिमिलरली आप आपका एक्सेप्टेंस भी रिवोक करते हैं जब तक वो मेरे ऊपर बाइंडिंग नहीं है. नाउ आई विल गो अहेड. अदर रूल्स, nitty-gritty of other rules you can little bit read in detail in section 4, 5, 6. Then you will understand the legal sanctity of that. Now I am going ahead. I made I said about something about consideration as such. Okay. And I said consideration is something in written. But now what is consideration? The definition is given in section 2 subclause D of the Act. What is that? Now, see, I said something in written. ये तो बहुत simple है, बोलने के लिए बहुत simple है. कानूनी तौर पे we have to look into the definition, and the definition is given in section 2 subclause D of the Act. 2 subclause D talks about, and it is a clumsy definition. No doubt, for the sake of understanding, keep in mind कि जो भी मैं आपको, when I am selling my flat to you for 1 crore rupees, so your 1 crore rupees is consideration for me, and you are giving me 1 crore rupees. In return, I'm giving you a flat. My flat is consideration for you. Okay. My flat is something which you are getting in return of your 1 crore rupees. And I'm getting 1 crore rupees because I'm losing my flat. I'm giving my flat to you. So your 1 crore rupees is consideration for me, and my flat is consideration for you. How it works? Definition of consideration says, when at the desire of the promisor, promisee, that means you, promisee or any other person, आपका भाई, आपका friend, when at the desire of the promisor, promisee, that means you or any other person has done something, okay, उसको भी consideration बोलते हैं, does something or promises to do something, ये तीनों भी चीजें मेरे लिए consideration हो सकती है. Okay, first of all, I will tell you the text of the definition. When at the desire of the promisor, promisee has done something, does something, or promises to do something, okay, or abstain from doing something, to such an act or abstinence or promise is called as consideration for the promise. अभी ये थोड़ा एक्सप्लेन करने में अपने पास ज्यादा टाइम नहीं है, बट शॉर्ट में मैं बताने की आपको कोशिश करता हूँ कि एट माय डिजायर, मैंने आपको प्रपोजल किया, विल यू परचेस माय पल्सर बाइक फॉर 50,000 रुपीज. एट माय डिजायर, प्रॉमिस हैज डन समथिंग, आपने डायरेक्ट मुझे 50,000 रुपीज भेजे, हो गया क्या कंसिडरेशन? यस, हो गया. सो दैट इज कंसिडरेशन फॉर मी. प्रॉमिसी डज समथिंग, दैट मींस आइदर इन द पास्ट you have given me consideration, at present you are giving me consideration, or you promise to pay this consideration in future. आपने बोला कि सर मुझे बाइक पसंद है, मैं नेक्स्ट मंथ में आपको पेमेंट दे दूंगा, चलेगा? मैंने बोला हाँ चलेगा. दैट इज आल्सो फाइन. सो दैट मीन कंसिडरेशन मे बी अ पास्ट कंसिडरेशन, जो कॉन्ट्रैक्ट होते वक्त आपने ऑलरेडी मुझे पैसे दिए हैं, सपोज फॉर सम रीजन. ओके, So, and therefore that can be a past consideration. Present consideration, I'm giving you bike and you are immediately giving me amount, or I'm giving you promise to give my bike in next month. You are also giving me promise to pay in the next month, and that is future consideration as such. Such an act or abstinence or promise is called as consideration. So, आप जो भी काम करते हो, that means act of giving me a price is a consideration. Okay, abstinence. If I say, don't come to my home for 1 month, I'm studying for judicial examination. If somebody very close friend, I will after that I will give you 10,000 rupees. So you are promising your friend not to visit your home for 1 month because you are preparing. You don't want to get yourself disturbed. So that abstinence of your friend refraining himself from coming to your home is also consideration for you, and therefore you are ready to pay him 10,000 rupees after 1 month. Perfectly all right. Or both of you are giving promises to each other. That is also perfectly all right as such. Okay. So the question is, consideration becomes legal when you are doing it at my wish, at the wish of the promisor. Okay. Aapko Dr. Rajendra Anbule has told me, no, give acceptance to Chaudhari sir. If I have not made you proposal, you cannot give any consideration to me. So you must move. You must give consideration as per my wish. That is, it may be through act, or it may be through abstinence, or it may be through your promise as such. Okay. Your consideration need not be adequate. Okay. So suppose I am the pulsar ka कीमत है 1 lakh rupees. I am giving it for 50,000 rupees. If I am happy, Mia Bibi Raji to kya karegi? Prakash, no problem. So consideration need not be adequate, but there must be consideration. Okay, it must be real. It should not be illusory. If I say, I promise to give you my bike, if you give me, say, so you do some kind of a magic for me. Not possible. It's not realistic. So consideration must be real. It should not be something which is illusory. I would say, no, I will give you 10,000 rupees. Convert this particular watch, as I said, into some kind of a golden ornament. So that is not possible as such. So that is also required. And consideration should not be illegal. It should not be something which is immoral. It should not be something which is opposed to public policy also. So that is also very, very important, which you must keep in mind. And therefore, therefore it is always said that if there is no consideration, then there is no contract. So, or they say that agreement without consideration is void. जो agreement में consideration नहीं है, वो agreement void होता है, वो enforceable नहीं होता है. Okay, ये हमें important है. But that rule has got certain exceptions, and exceptions are given in section 25 onwards. Okay, in those sections they have given exceptions. कि कुछ exceptions ऐसे हैं कि even if they are not, the agreement is not supported by consideration, still it is valid. What are those? There are a few exceptional situations. For example, and they are given probably in a certain section, like section 25. Okay. Anyway, so my point is, I don't want to refer a very categorical sections, but that is there. So, for example, the section 25, and there are certain sub-clauses which talks about contract without consideration is void. Agreement without consideration is void. So, but in exceptional situation, agreement is perfectly valid even if there is no consideration. Number one, if there is an agreement out of natural love and affection, reduced in writing, okay, and registered, it is valid. If as a father, I promise to pay 10,000 rupees to my daughter if she passes LLB examination in flying colors in first class, then I promise to do that. Or even otherwise, I am happy and I said, my dear daughter, I promise to give you 10,000 rupees. She is asking me, Dad, why for? I said, कुछ नहीं, मैं आज बहुत खुश हूँ इसलिए मुझे आपको 10,000 rupees देती. If she is learning law, she would probably ask me, Daddy, please give me this promise, make this promise in writing, and we will register it. And we will complete all legal formalities. If it is registered, duly on a duly stamped paper, written and registered, even if she is not giving me anything in return, that agreement is valid even without consideration as such. Promise to pay time barred debt. Sometimes debt is time barred. When debt becomes time barred. So if you haven't make repayment within 3 years, and as you know, Indian Limitation Act talks about, you cannot file case after 3 years of the last date of repayment. वो 3 साल हो गए, आपने केस फाइल नहीं की, and still gentleman came, the debtor comes and says, sir, Mr. Chaudhari, I promised to pay you the debt, which is actually time barred, but I feel like you have helped me, and if this agreement you are making, and if it completes all other formalities, when now you are legally you are not liable to pay me anything because the debt is time barred, but still you are making it in writing and again giving it in writing, and I say okay, so that agreement is without consideration is perfectly valid. Third is completed gift. If I have gifted some property to my daughter, I have already given it without getting anything in return, I cannot demand that property back because I have already done it. Law says, okay, now Mr. Chaudhary, stop from bringing back the gift which you have given to your daughter. Okay, if I have agreed to contribute for some charitable trust, some amount, I promised to pay a charitable trust, I said, okay, fine, you can give certain amount. I will give you certain amount by way of donation. And then you said, okay, sir, we will purchase certain necessities in the pandemic situation. And we will distribute certain food grains to the needy people. I said, that's fine. So if I have promised you that I will promise 10,000 rupees, believing on this promise, you purchased certain grocery and already distributed to certain people, then this my promise to pay for charity is valid without consideration because they are not giving me anything in return, but still my contract will be perfectly valid because it is promised to subscribe for charity as such. So all such type of factors are, we say they are agreements without consideration as well. I said a stranger to a contract cannot file case against me unless you are a beneficiary or there is a trust and you are a beneficiary. So doctrine of privity of contract is there. If contract is between you and me, the promisor and promisee, if there is a breach of contract, only you can file case against me or I can file case against you. Third person cannot file, stranger to a contract cannot file case against me. However, if stranger is a beneficiary, if there is a assignment of a contract and then the stranger gets a right, or if the agent, though he's not a party to the contract, but on his behalf, he's entering into a contract. In certain such type of documents, you will find even stranger can take action against you as such. Going further, one more condition required for valid contract is competent parties. I made a reference of competent parties. When you become a competent, I said that you should be a major. Major means you must have completed 18 years of age. There are two exceptions under Guardians and Wards Act. They have very specifically mentioned that where the particular person, the guardian has been appointed, okay, to a particular child, then that child would attain age of majority when he completes 21 years of age as such. So therefore, the person becomes major when the minor becomes major if he doesn't have parents and somebody really, as per the Guardians and Wards Act, he will attain majority only when he completes 21 years of age, or if his property is under superintendence of the guardian. So there is no guardian is legally appointed, but property is in the hands of some guardian or legal guardian. In such circumstances also, that minor becomes major only when he completes 21 years of age. So then only you become major, major. And when you attain the age of majority, you become competent to enter into a contract. Okay. Second point is that you should be, you must be having a sound mind. And sound mind is when you are in a position, you are capable of understanding the terms of the contract, and you are in a position to form a rational judgment about the consequences of your contract on your own interest. ये कॉन्ट्रैक्ट करने के बाद मेरा फायदा होगा या तोटा होगा, ये समझने का रैशनल जजमेंट रैशनल माइंड अगर आपके पास है तो आप साउंड माइंड है, ऐसा डेफिनेशन आपको बोलेगा. Okay, and therefore you should be in a position to know that whether you are of a sound mind or not. And third, you are not disqualified by law, very specifically that you are disqualified by law from contracting. And if you are disqualified by law from contracting, like you are alien enemy, so or you are insolvent person, you are a drunkard person, is there a certain or you are a foreign ambassador where I cannot take action against you. There are certain people who are disqualified by law from contracting, and then still you are dealing with them, then that contract will not become a valid contract as such. So all that particular factors you must keep in mind, that there are these people or convicts, the person who is already in jail undergoing the punishment as a penalty, such person is not competent to enter into a contract. Similarly, insolvent person who is declared by law to be insolvent, he is not capable of entering into a contract. So all such factors you should be in a position to keep in mind so as to become that you are not disqualified by law if you want to become a competent person. You are not a minor person and you are not a person of unsound mind. So these are the three prerequisites. That means you must be a major, you must have a sound mind, and you must not be disqualified by law from, you should not be disqualified by law from contracting. Okay. Now, question is not that if you are a major, if you are sound mind, and if you are not disqualified by law from contracting, you can enter into a valid contract. That is not the question. Question would be if you are a minor, if you are having unsound mind, and if you are disqualified by law, and still you are entering into a contract, then that contract will not be a valid contract. Minor's agreement is void. Moheri Bibi versus Dharmadas Ghosh, Privy Council has very categorically mentioned that minor's agreement is void ab initio. Ab initio ka matlab hai void from the beginning itself. So right from inception only, minor's agreement is void because he is not competent to enter into a contract. That is more important. But minor can be a beneficiary to the contract. Minor can become, he cannot become a partner, because for becoming partner, you should again complete 18. But you can be added to the benefits of the partnership firm. Okay, I can give some chocolate to the minor, and if he's beneficiary, he has no problem. He need not pay me some amount for that. Okay, so all these things are there. If I have supplied necessaries to the minor person, okay, I cannot hold him liable for the necessaries suited to his life, whatever I have given him, food, clothing, shelter. I cannot file case against a minor and recover that amount. At the most, I can file case against a guardian of that minor. And if minor has got some property, I can recover certain amount from the property of the minor, but minor is never ever personally liable in any kind of a breach of contract as such. However, minor's property may be held liable in certain exceptional situations as such, like necessaries supplied to a minor can be there. Minor can act as an agent, because agent brings two parties together and contract is formed between two parties with the help of agent. Agent himself is not a party, so there is no problem for minor to become an agent as such. Okay. Similarly, therefore, if you are lunatic, you are mentally unstable, a person is idiot. Now, idiot is defined as whose mental faculties are not at all developed. हम बोलते हैं कि पगला कहीं का, idiot इतना भी नहीं समझता. Now that idiot word has lost its significance because of frequently using that term in our day-to-day life. Idiot means a person whose mental faculties are not at all developed, and he is therefore not of sound mind. He cannot enter into a contract. These are the misnomers. We are wrongly using these terms technically as such. Okay, lunatic, I am not in good state of mind. Sometimes I am getting frequent attacks of sanity and insanity. Diseases, okay. So I become insane sometimes. I'm a drunkard person. I'm not in senses and enter into agreement. I am of unsound mind. Okay, I'm intoxicated because of certain medicines. I don't understand what is right and wrong. I'm under the influence of drinks, influence of drugs, influence of medicines. In such circumstances, criteria is, am I in a position to form a rational judgment about the consequences of my own acts on my own interest? If answer is, I am not in a position to understand what is happening, whether what is right and wrong for my own interest, then I am temporarily of unsound mind, and I may not be considered to be qualified to enter into a contract as such. So all these essential things are required if I want to make a, then only I am considered as I am capable of understanding what is right and what is wrong, and I become capable to enter into a contract. Sometimes they do ask a question of, I said, one more ingredient is required to make your agreement as a valid contract, that is free consent. And free consent is, the word consent is defined in section 13, and free consent is defined in section 14 of the Act. So you can find out, and then free consent is required, as I said in the beginning. What is consent? In Roman law, we call it as a consensus addendum. And consensus addendum means concurrence of minds. Concurrence of minds means meeting of minds. Meeting of minds means when two or more persons agree upon same thing in same sense, then we say that one person is consented to the other person. So when I agree, both persons agree on same thing in same sense. Okay, like in Mahabharata, you must remember that Ashwatthama. So whether Ashwatthama is dead, but which Ashwatthama, human being or elephant? Then we know the very famous dialogue, Narova Kunjrova, कि नर था या animal था, पता नहीं है. Yudhishthira also was compelled to not to disclose the entire truth. So point is, in such circumstances, Ashwatthama, they didn't agree upon same thing in same sense. Similarly, when I agreed to sell my pulsar to you and you paid me 50,000 rupees, and when you came for delivery, I called my pulsar. I said, oh, hello, pulsar, come. And one my nice dog comes to me and I say, please take this particular dog. You say, sir, what is this? I wanted to get a bike and you are giving me a dog. Yes, I said, everybody knows my dog's name is Pulsar. Is it possible? Then point is, there was no consent, no consensus addendum, no concurrence of mind. Why for? Because both of us have not agreed upon same thing in same sense. Section 14 talks about free consent. Consent is said to be free if it is not obtained by coercion, undue influence, misrepresentation, fraud, or by mistake. 5 elements. If the consent is given by any one of these 5 elements, these 5 elements are nothing but flaws of the consent. These flaws will adversely affect your consent. Your consent will not continue to be a valid consent because it is given because of these 5 problems, 5 flaws, 5 hurdles. Which are these hurdles? Coercion, undue influence, fraud, misrepresentation, mistake. What is coercion? Coercion is again defined now. Rest of the section like 15, 16, 17, 18, 19, 20 talks about all these things. I will be going a little bit fast because we have a paucity of time. But consent, the coercion is defined that if you agree to do something, committing or threatening to commit an act forbidden by Indian Penal Code, so or unlawfully detaining someone or threatening to detain someone's property and thereby giving your consent is coercion. Coercion means force, criminal force you are applying. That means if I say, or if you say now, sir, you have to sell your Pulsar bike. Now I am using the word bike. If you don't, you have to sell your Pulsar bike to me for 5,000 rupees. If you don't sell this bike to me, and you show me a pistol. And at the pinpoint of revolver, I'm saying yes. What is this? This is threatening to commit an offense, mentioned in the Indian Penal Code. Okay, or actually committing an act. Okay, you are actually committing, you have abducted me or you have kidnapped my child, and then asking, sir, काली पहाड़ी के पीछे 10 लाख रुपीस लेके आना, नहीं तो आपका बच्चा आपको नहीं मिले. और मैं बोला हाँ लाता हूँ. ये हाँ जो मेरा कंसेंट है, ये कंसेंट फ्री नहीं है. It is obtained by coercion. You have detained my property, and then I am saying yes. This is coercion. This is forcefully giving consent. Is coercion as such. There are so many threatening to. Even if a family member sometimes says, if you don't sign these documents, release deed, brother is going to the sister and asking sister, मेरे बहना आप तो बहुत अच्छी है, ये रिलीज डेट के ऊपर सिग्नेचर करो, पूरे प्रॉपर्टी मेरे नाम पे, शेयर आपका रिलीज करो मेरे नाम पे. आप अगर नहीं करती हो, I will commit suicide. Attempt to commit suicide is prevented by Indian Penal Code. Therefore, this is also a coercion. And if she signs that release deed will not be binding on her, which we have to keep in mind. Second flaw is undue influence. Undue influence में आप force नहीं करते, और अच्छा influence करते हो. Maybe doctor and patient है, teacher and student है, आपका maybe आपका senior and junior lawyer है. And therefore, in such circumstances, if you are saying yes because of the position, so in undue influence, one person is in a position to dominate his will over the other. Okay, so therefore, if a teacher is asking his student, let's sell your bike, market price is 50,000 rupees, and teacher asks, give me 30,000 rupees, and student cannot say no, and he said yes. Why? Out of respect, out of dominant position of a teacher, out of doctor and patient में भी हो सकता है, टीचर और स्टूडेंट में हो सकता है, सीनियर जूनियर में भी हो सकता है, मास्टर एंड सर्वेंट में हो सकता है. पॉइंट इज आपको ना कहने का था, बट फिर भी आपने हाँ कहा. क्यों? जबरदस्ती नहीं है, बट पोजीशन ऐसी है, यू कुड नॉट से नो. दैट इज व्हाट वी से अनड्यू इन्फ्लुएंस. और अनड्यू इन्फ्लुएंस से भी आपने हाँ बोला है, तो वो कंसेंट वैलिड कंसेंट नहीं है. तो कोर्शन में एक्चुअल फोर्स है, अनड्यू इन्फ्लुएंस में फोर्स नहीं है, बट मॉरल प्रेशर इज देयर. सेक्शन 17 टॉक्स अबाउट फ्रॉड, चीटिंग. आप किसी को चीट करके अगर उसकी कंसेंट देते हो, गलती से वो अगर कंसेंट देता है, intentionally deceiving the other party, you are obtaining consent. You are saying no ये टाइटन का घड़ियाल है, ये टाइटन नहीं है, ये टाइफन है. अगर आपने मैंने आपको ये गलत बात बना के मैं अगर आपको चीटिंग करता हूँ और आपकी कंसेंट लेता हूँ, that consent is obtained by fraud, and your consent is not free, and contract will not be a valid contract as such. Similarly, misrepresentation, because of not having sufficient knowledge, I don't know कि ये वॉश की कीमत 10,000 है. I thought it must be 1,000 rupees. I am selling it to you, and it's a misrepresentation. Sometimes because of ignorance, I am making wrong statement. Okay, I don't know that ये टाइटन का वॉश है, but I bona fide believe कि ये टाइटन का है. Actually वो नहीं है, but मुझे knowledge नहीं है. Because of my ignorance, I am making a wrong statement. Okay, and you believed it to be true, and you said yes. Okay, your consent is obtained by misrepresentation, though there was no intention from my mind to cheat you. This is the difference between fraud and misrepresentation. In misrepresentation, आप गलत बात बोलते हो, इंटेंशन अच्छा रहता है. फ्रॉड में गलत बात बोलते हो, इंटेंशन सामने वाले को डिसीव करने का है. और मिस्टेक, गलती से आपने एरोनियस बिलीफ, गलती से आप हाँ बोलते हो. It may be ignorance of law है, तो ignorance of law is not excuse, agreement remains valid. But mistake of law of the other country is treated as mistake of fact, and mistake of fact is probably excusable, and mistake of fact है तो contract void होता है. उसमें काफी अलग अलग चीजें हैं, वो भी आपको थोड़ा देखना पड़ेगा. Okay, so you just see all these particular aspects as such. And now I'm saying that lawful object and lawful consideration, that was also another point. And object and consideration will become lawful only when that the very basic objective, if it is not against a public policy, if it is not going to defeat the provisions of law, if it is not going to violate the provisions of law, these are the, if it is not immoral, if it is not against law, if it is not against public policy, then only your object and consideration of a contract will become lawful. Okay, and if your object and consideration is unlawful, that contract also becomes a void contract as such. Okay, so this is also a point which you must probably keep in mind as such. Okay, so that is the another aspect which you take into the consideration. You will find that how it becomes a matter of importance. Now, at this particular point of time, I have discussed when valid contract happens. I have discussed legality of proposal, discussed legality of acceptance. I have discussed with what is consideration, what is lawful consideration, what is lawful object, when agreement is valid without in external situation without consideration. Also, I have also discussed with free consent. In some of the examinations, they have asked the question on free consent also. In such circumstances, what is the consequences of these 5 flaws on the nature of contract? Now I will tell you, somebody had asked a question, voidable contract. So if your consent is not free, if your consent is obtained by coercion, undue influence, fraud, and misrepresentation, first 4 elements, okay, your consent is not free. What is the nature of contract? Contract becomes voidable contract. और voidable contract का मतलब है आपकी consent free नहीं है, आपको हक है उसको void करने का या valid करने का. Voidable का मतलब है capacity of becoming valid as well as void. मगर वो right is only having to the person whose consent was not free. मैंने अगर आपका consent coercion करके forcefully लिया है तो मैं वैलिड नहीं कर सकता. वो वैलिड करने का है या इनवैलिड करने का है, वॉइड करने का है या वैलिड करने का है, वो हक आपको है. आपको मतलब जिसने कंसेंट दिया है, एंड जिसने कंसेंट 4 फैक्टर से अगर दिया है तो आपको वॉइडेबल कॉन्ट्रैक्ट है, वो आप वॉइड कर सकते हो. आपने कुछ भी ऑब्जेक्शन नहीं लिया तो ऑटोमेटिकली दिस कॉन्ट्रैक्ट आल्सो बिकम्स वैलिड. ओनली if it is ignorance of law, that is mistake of Indian law, agreement becomes perfectly legal. But if it is mistake of fact, then that contract is likely to become void. वो थोड़ा डिटेल जो है वो आपको पढ़ना पड़ेगा, उसके लिए अपने पास ज्यादा समय नहीं है. Okay, we go ahead with now. Once the contract is formed, now you have to perform a contract. You know why contract is made? The contract has been made. The very basic fundamental objective of a contract is that it must be performed. Okay, why contract? Object is, William Anson has very categorically mentioned that what has been promised must be performed and what has been led to expect must be complied. इसका मतलब ये है कि जो वादा किया था वो निभाना पड़ेगा. कॉन्ट्रैक्ट का पर्पस क्या है? जो आपने प्रॉमिस किया है वो आपको परफॉर्म करना पड़ेगा. हमारी संस्कृति में हम बोलते हैं कि प्राण जाए मगर वचन न जाए. आपने प्रॉमिस दिया है तो परफॉर्म करो. आप आजकल प्रॉमिस परफॉर्म नहीं करते हो तो कानून बनाना पड़ता है, इंडियन कॉन्ट्रैक्ट एक्ट बनाना पड़ता है, और वो आपको बताता है कि यू हैव टू परफॉर्म योर पार्ट ऑफ कॉन्ट्रैक्ट. ओके, इट इज योर मॉरल, नाउ इट इज योर लीगल रिस्पॉन्सिबिलिटी. इफ इट इज अ वैलिड कॉन्ट्रैक्ट, इट इज योर रिस्पॉन्सिबिलिटी. Now there are sections of performance of a contract. They are given in section 37 to 39, and they are very categorically mentioned that it is a duty of the promisor to actually perform the contract or make offer of performance. उसको हम बोलते हैं tender of performance. Okay, so if I have made a contract to you of selling of my flat for 1 crore rupees, I will say, sir, now I am ready to perform my part of contract. What about you? This is called as offer of performance. Now, this offer of performance should also be a valid offer of performance. That means it must be made to a right person. It must be in consonance with the actual original proposal. It must be made to the right person, right time, and at a reasonable mode and right place. Then my offer of performance is valid. This is also called as attempted performance. So, when contract is formed, at the time of performance, again, the promisor will have to make offer of performance. And if the promisee says, okay, sir, perform your part of contract, then I will perform my part of contract. But if you say, sorry, I will not pay, then I will say, sorry, then I will also not perform. So once I have offered you my part of, when I am showing my readiness and willingness to perform my part of contract, law is discharging me from liability to perform my part of contract. In short, I have two options: either actually perform my contract or I have to make attempt to perform my part of contract by making offer of performance. And if I make valid offer of performance, it is as good as I have performed my part of contract. And then I'm discharged from liability to perform if other person does not respond to my offer of performance. Okay. So who has to perform who has to perform the contract? Naturally, promisor has to perform the part of contract. Promisee, to whom proposal was made, promisee can demand the performance, or any legal representative of the promisee can demand the performance. There is a possibility that there is a joint promisor from one side and joint promisee from other sides, like a partnership firm. If there is a partnership firm and there are three promisors one side and there are three promisees at other side, who is under obligation to perform part of a contract? All promisors are jointly and severally liable or under obligation to perform their part of contract. So, तीन लोग हैं, like a partnership firm, they promise to pay say 3 lakhs rupees to you. So you can recover 3 lakhs rupees from any one of them, any two of them, or all of them. Okay. You can discharge one of them. आपका कोई एक फ्रेंड है ABC से, आप बोलते कि नहीं ए आप मुझे पेमेंट मत करो, फिर भी रिमेनिंग दोनों से आप पेमेंट वसूल कर रहे हो, तो वो दोनों को पेमेंट देना पड़ेगा. Or that A is also liable to share his responsibility from other two partners. Keep in mind, even if you are discharging him, other two, his co-promisors, may not discharge him. Okay. Similarly, who can demand the performance? All promises will have to demand the performance. All promises will have to show their readiness and willingness to perform their part of contract. So if partnership firm को अगर आपने promise किया है, वो promisee है, तो all three partners or all promisees jointly should demand the performance, and then only it becomes a valid performance as such. This is what we are talking about: joint liabilities of promisors, or devolution of joint rights and devolution of joint responsibilities. And again, it must be made at right time and right place. And time and place, if it is not specifically mentioned, then we see that it becomes, the contract gets discharged, or you have to perform a contract within a stipulated time, or within a reasonable time, or within a reasonable mode, or at a reasonable place, in absence of very specific terms and conditions as such. Okay, just give me a break of 1 minute. I will be back. Excuse, so sorry for 1 month's break. One minute. Okay. Now you will find that sometimes they do ask a question on reciprocal promises. What are the provisions with regard to reciprocal promises as such? And if you see the provisions, you will find that there are provisions of reciprocal promises. They are from section 51 to almost, it goes to section 66, 51 to 56 initially, and there are certain provisions whereby reciprocal promises are required to be performed. Okay. Now, question is again, what are these reciprocal promises? Then if the question is on the reciprocal promises, you will have to discuss all this particular section 51 onwards, and you have to also define what is a reciprocal promise. What is a reciprocal promise? Section 2F defines the reciprocal promise, and it says that promises which form consideration are part of the consideration for each other are called as reciprocal promises. Like when I have also tried to define the acceptance, or when we discussed the definition of agreement, I said agreement is a promise or set of promises forming consideration to each other. So when two promises are forming consideration to each other, it means my promise is consideration of your promise, and your promise is consideration of my promise. And if they are required to be performed reciprocally, then they are called as reciprocal promises. That means you will find that when I discussed the definition of consideration, that when at the desire of the promisor, promisee has done something, okay, or abstained from doing something, does something, or abstain from doing something, or promises to do something, or abstain from doing something, such an act or abstinence or promise is called as consideration. Okay, so there the last line talks about that I'm giving you one promise, and in return you are giving me another promise. Okay, so there is an exchange of promises, and when there is an exchange of promises, it becomes a reciprocal promises, and that is what section 2F decides, that one promise is the consideration of other promises. And in such circumstances, when you talk about the performance of these reciprocal promises, then there are certain rules which are required to be followed, and these rules are very important as such. Sometimes they are mutual and dependent. Reciprocal promises are mutual and dependent. That means if you perform, then I will perform. Similarly, you will also say, if you perform, then I will perform. It means what? Okay, suppose presuming the giving pulsar to you for 50,000 rupees, I would say, okay, if 50,000 rupees ready, then you will also show the pulsar bike. Bike is ready? Oh yes. Are you ready to give? I said yes. Okay, if I am ready and willing to give my bike, you are also ready and willing to give your 50,000 rupees. But it is mutual and dependent. That means if you perform, then only I will perform. And if you do not perform, I will not perform. So I asked you, are you going to pay me the 50,000 rupees? He says, sir, abhi to nahi hai. Sorry, then I will not perform. Not only that, if I offer you a tender of a performance, even in case of a reciprocal promises, and you are not ready to perform, then I need not perform my promise, and I get right to rescind the contract. That means I get right of rescission of a contract, rescind the contract. To rescind the contract is nothing but to cancel the contract. Okay, that right I get because the agreement or the reciprocal promise is mutual and dependent. Sometimes the order of performance is mentioned. I said, if first of all you will have to send me bricks, then I will construct a wall for you. That means my performance is dependent upon your performance. So it is a dependent, mutual and independent. So therefore, only one party's performance is dependent on the other party's performance. Therefore, you have to do something, then only I will perform the contract as such. So the order in which the reciprocal promises are to be performed is expressly fixed by the parties themselves. And that order has to be followed. I said, आपको पहले brick देने की थी, बाद में मुझे wall construct करने की थी, तो आपको पहले brick देनी पड़ेगी. ये भी reciprocal promise की जो order है, order in which you are supposed to perform your part of contract, sometimes is clarified. That order is required to be performed as such. Sometimes when contract contains the reciprocal promises and one party to the contract prevents the other person in performing, then contract becomes avoidable. So I am ready to give my bike to you, okay, and somebody from you have sent somebody and he is putting a revolver behind me, and you said, Chaudhari sir, if you give this bike, I will kill you. I cannot perform the contract. That means, and you are instrumental in that. So point is, if reciprocal promises are there, but you are not allowing me to perform my part of the contract, then that contract becomes voidable. Then it is up to me. I may, with that threat, I can sell you the bike, or I would take a call to make this contract as a void contract because you are using threats. You are not allowing me to perform my part of contract, and you are creating problem for me. So that is also there. And sometimes you will find that if the other party fails to perform his promise in reciprocal promises, there was some time limit which you were supposed to perform your part of contract. You have not done that, and in such circumstances, you can cancel the contract and file a case for compensation, even in case of a reciprocal promises. In reciprocal promises also, sometimes time is the essence of a contract. Okay, if say time is a very, very important factor, then you have to perform the contract at a right time. So, and if that time is not followed, then other party get right to rescind the contract. So if time is the essence of a contract, then time, the performance of contract must be done at right time. If you are delaying that, then other party need not accept your performance, and that contract can be rescinded, cancelled by the other party because time was the essence of contract. If time is not the essence, and you perform, you have delayed, you have performed your contract with some delay, other party has not objected for that, then you cannot rescind the contract, you cannot cancel the contract, but you can definitely ask for compensation as such. Okay, there are certain rules with regard to how to appropriation of payment. The creditor or debtor में जो payment देने का है, तो कैसा देने का है? Debtor, you have given me 10 lakhs rupees. Say 2 lakhs rupees, 2 lakhs rupees, 2 lakhs. There are 5 contracts of 2 lakhs. I have to make repayment. How to make this repayment? How to make appropriation of payments? If I told you कि मैंने जो 2 नंबर का पेमेंट पैसा लिया था, वो आप अभी ले लो मुझे, ये 2 लाख. So you have to follow that. If I did not give any kind of a specific instruction, जो सबसे पुराना डेट है, वो आपको पहले लेना पड़ेगा. फिर consecutively, depending upon the series of transactions, the series of payment which I have made, you have to appropriate that amount depending upon the first contract को पहला पेमेंट जाएगा, दूसरे कॉन्ट्रैक्ट को दूसरा पेमेंट जाएगा. ये आपको appropriation of payments के भी rules है. और मैंने अगर कुछ भी नहीं किया है, तो the creditor can utilize that amount at any point of a time as such. Okay, there is an assignment of contract when it has been there. So the one person will be substituted once I have transferred my contractual rights and obligations to someone else. Then someone else will be sitting in my shoes and he can continue the contract. And this is what we say the assignment of a contract as such. Okay. Now, question is how contract comes to an end. Okay, and that is what we call it as a discharge of contract. When contractual obligations comes to an end, we say contract is discharged. Why? Because contract is creating rights and obligations amongst the parties or between the parties through their own terms and conditions. When that contract will come to an end, contract will come to an end by various ways. And when rights and duties, rights and obligations will come to an end, we call it as a discharge of contract. Is it okay if I take 10-15 minutes more so that I would be in a position to discuss the remaining sections? There are 1 or 2 topics are there. I may require 10 to 15 minutes. Will that be fine?
No, sir. No problem, sir. No problem. You can continue.
Okay, thank you so much. Yeah, because I think now, as per the schedule which you have given, the time is up. With kind consent from the coordinators, organizers, and all dear participants, I will take another 10 to 15 minutes and finish the topic which was given to me. Now, discharge of a contract. So, contract will come to an end through various ways, and those various ways have been also mentioned in the Contract Act as such. Okay, and they are given in section 62 to section 66 by and large. Now, discharge of a contract. Okay, one is contract will come to an end. The contract will be discharged by actual performance of a contract. One, contract will be discharged by actually breach of contract. Okay, contract will be discharged by mutual consent of the parties. Okay, contract will be discharged by supervening impossibility. So you will find there are different ways in which contract will come to an end. One is by mutual consent. Both the parties, मैं अभी भी राजू तो क्या करेगा? Parties ने बोला कि नहीं, मैंने आपका बाइक नहीं लेने का है सर, मैं बोला मुझे भी आपका बाइक नहीं देने का है. Contract comes to an end by mutual consent. Okay, contract comes to an end by supervening impossibility. मैं आपको बाइक देने का मैंने वचन दिया था और बाइक got destroyed in the accident. Contract will come to an end. If any one of the parties died and the contract is dependent upon the personal skill, suppose an actor dies, actor working in a serial dies, his legal heirs cannot be substituted on that particular contract because contract was of a personal skill and nature. Contract will come to an end. Contract will be considered as a discharge. Or if there is a change of law, there is outbreak of war, there is destruction of subject matter. For such type of a valid legal position, something happens after the formation of contract, but before the performance of the contract comes to an end as such. Okay. Sometimes, therefore I said, sometimes there is a merger of a contract, there is an insolvency of a person, there is unauthorized alteration in the terms and conditions of a contract, and then because of such type of a supervening impossibility or because of such type of breach of contract also, the contract actually comes to an end. Okay. Sometimes there is change, novation of a contract. Earlier contract, instead of earlier contract, you are substituting new contract of that. Instead of Pulsar, I said now I will give you Hero Honda, and you also agreed. The entire contract is changed. Sometimes parties to the contracts are also changed. This is called as novation of a contract. Rescission of a contract, if other party or mutually you can cancel the contract, or one of them is cancelling the contract for justifiable reasons. By alteration of a contract, original contract comes to an end. Remission of contract, you were supposed to make repayment of 10 lakhs rupees. I said, okay, I will discharge your liability even if you pay me 8 lakhs rupees. If this is happening with the mutual consent, that is called as remission. Contract is discharged with the mutual consent by alteration, novation, rescission or waiver. आप मुझे 10 lakhs rupees देना है, मैंने बोला मत दे दो. Contract comes to an end. Merger. I was a tenant and now I purchase the property. I need not pay you the rent because I become the owner. So original contract of payment of rent will come to an end. Point is, contract will be discharged by this way. Contract will be discharged by breach of contract by the other party. Contract will be discharged by lapse of time. So you were supposed to perform a contract on so and so date. The date is over. You have not done your part of contract, and because of lapse of time, contract comes to an end. Sometimes contract comes to an end because of breach of contract. When you commit a breach, and this is why the law is made. The entire Indian Contract Act is made for this one reason, that if somebody commits breach of contract, you should be in a position to go to the court of law, take action against him and get the remedies. What are the remedies for a breach of contract? The remedies are various remedies, which I have already discussed. One is rescission of a contract. That is cancellation of the contract. If you don't perform the contract, I will cancel the contract and I will file case against you in the court of law for getting me damages or compensation. That is one. What do I ask in the court? You have done breach of contract, so pay me the compensation. And what is that compensation? We call it as a damages. What are the damages? Damages are considered as monetary compensation payable by wrongdoing party to the aggrieved party. Wrongdoing party is party who commits breach of contract. Okay. So damage and damages, there is a difference in that. What is damage? Damage is actual loss, and damages is the monetary compensation payable for compensating that particular actual loss which has happened. Okay. So whatever loss I suffered because of a breach of contract, I will ask for damages. I will ask for monetary compensation from other party. That is what we call as suit for damages. This is the second remedy. Third remedy is suit upon quantum merit. Quantum merit is as much as is earned. I asked you to complete 3-story building for me for 30 lakhs. You completed only 2-story. I will pay only 20 lakhs rupees. If you don't construct third story, I will not pay remaining 10 lakhs. So this is called as quantum rate. जितने quantity का काम किया है, उतना ही compensation मिलेगा. Okay. So then another remedy is suit for specific performance of a contract. If compensation is not an adequate remedy, then I will insist the other party to perform your part of contract specifically. Okay, and that will be under the Specific Relief Act, which you must have studied. So specific performance can be asked only when the monetary compensation may not be adequate. Okay, and in such circumstances, आप बोलेंगे कि नहीं आपको वही है. That is an antique piece which I wanted to purchase from you. Sell that antique piece to me because I cannot get antique piece elsewhere. I have that emotional attachment with that antique piece. Then you have to specifically perform your part of contract. What has been agreed, perform it. And filing suit for specific performance is that sometimes you agreed to sell that antique piece to me, and now you are selling it to another. I got information that you are about to commit breach of contract. By selling that piece to someone else, I can file suit for injunction. Injunction is prohibitory order stopping a particular person from doing something. That is also a remedy available in case of a breach of contract as such. So I don't want to discuss all those different things, but damages I will have to discuss. So there are ordinary damages, normal loss hua, so normal damages you can ask, and therefore you will find section 73 to 75 do talk about how to quantify these particular damages. And you will find Hadley versus Baxendale is a remarkable case in this case. And whatever the decision which was given in long back in 1856-57, those rules have been enumerated in our 1872 Indian Contract Act as it is. And there they have mentioned that whatever loss you suffered out of a natural consequences of breach of contract, only that natural consequences of only that nominal, only that direct damages you can get. You cannot get indirect damages. You cannot get remote damages. You can get compensation for actual loss which you suffered, remote damages, indirect damages, excessive damages, vindictive damages, punitive damages will not be generally awarded. Liquidated damages are damages which you have quantified well in advance and written in the contract only कि हमारा breach of contract हो गया है तो ये amount of compensation हम देंगे, उसको बोलते हैं liquidated damages. वो आपको in that case also normally judges will grant only reasonable damages which are going to compensate the aggrieved party as such. However, in case of a breach of contract of marriage, sometimes in case of a breach of even the dishonor of a check also, your emotions are adversely affected. You may ask excessive amount of compensation. Punitive compensation means जो आपको penalty जैसे लगता है, but penalty जैसा clause आपने भी लिखा है तो उसके ज़्यादा compensation आप नहीं मांग सकते हो. Up to that penalty you can ask for the compensation, but generally courts will be granting the direct damages, actual loss, and not the indirect loss which you would have remote damages नहीं मिलते. कि मेरा for example ये आपने मेरी पल्सर नहीं 50,000 को ले ली, देखो मुझे उसमें 5,000 प्रॉफिट होने वाला था, वो 5,000 में शेयर्स में डालने वाला था और शेयर्स में मुझे करोड़ रुपीस मिलने वाले थे, तो करोड़ रुपीस नहीं मिले क्योंकि आपने बाइक नहीं ली, तो मुझे करोड़ रुपीस का कॉम्पेंसेशन दे दो. ये होगा indirect remote damages which will not be granted by any of the court as such, and that will not be possible and that will not be given. There are provisions with regard to quasi contracts, and quasi contracts are not contracts in fact, they are contracts in law, and there are certain sections of the quasi contracts are there. There are section 68 to section 72. They do talk about a quasi contracts as such. And in quasi contract, you will find sometimes that you have certain payment made by interested party or non-payment made by for non-gratuitous act, okay, or responsibility of finder of goods. So they are there. It means, in short, I would say, quasi contracts is not actually a contract. It is as like as contract. Okay, and law recognize certain relations resembling those created by contract. That is the terminology which has been used in the Indian Contract Act. Nowhere they have used the word quasi contract. We are calling them as a quasi contract. Relations resembling those created by contract. ये दो लोगों में ऐसा रिलेशन होता है जैसे कि वो कॉन्ट्रैक्ट है. एक्चुअली कॉन्ट्रैक्ट है क्या? एक्चुअली कॉन्ट्रैक्ट नहीं है, मगर वो कॉन्ट्रैक्ट जैसा ही है. कानून उसको कॉन्ट्रैक्ट बोलेगा. ओके, जैसे कि फाइंडर ऑफ गुड्स. ओके, सो आप फाइंडर हैं. मेरी से फॉर एग्जांपल मेरे ऑर्नामेंट, आई लॉस्ट माय ऑर्नामेंट ऑन द रोड. आपको मेरा नेकलेस, सोने का नेकलेस रास्ते में मिला. आपकी ड्यूटी क्या है? योर ड्यूटी इज लाइक अ बेलर, एंड दैट ड्यूटी इज that you have to find out the original owner and return the goods to the original owner. If they are perishable goods, then try to find out the owner. If you could not trace the original owner within the reasonable span of time, sell those goods in the market, get the money, again try to find out the original owner and return those goods to the original owner. This is the responsibility of a finder of goods out of a quasi contract. Law recognizes that relation. There is no contract between the finder and the person who is losing the goods on the street. Okay, so all those things are there, and they are specifically mentioned as such, and they are called as the quasi contract as such. There is another concept called as contingent contract. Contingent contracts are contracts which will be performed, or they will be performed on happening or non-happening on some future contingent event. Okay, so they are not to be confused with wagering agreements. Wagering agreements are betting agreements. Betting agreements means if it rains today, I will pay you 10,000 rupees. If it does not, you have to pay me 10,000 rupees. They are illegal. Betting agreements are void as per Indian Contract Act, and in Maharashtra they are illegal also. Okay, but contingent contracts like the insurance contracts. So if I will pay some premium, and if I die tomorrow due to some contingent event, insurance company will have to pay certain amount to my legal heirs. So that insurance contract is one of the best examples of contingent contract. Contingent contract will become valid because it is depending upon happening or non-happening of a future uncertain event. If it is on happening, अगर वो event होता है तो वो valid होता है. एक कंटीजेंट कॉन्ट्रैक्ट अगर नॉन हैपनिंग ऑफ सम इवेंट के ऊपर अगर निर्भर है, वो इवेंट अब जब नहीं होता है तो दैट कॉन्ट्रैक्ट बिकम्स वैलिड एज सच. सो प्लीज रीड दैट कंटीजेंट कॉन्ट्रैक्ट आल्सो इन डिटेल. दे आर कैटेगोरिकली मेंशन्ड इन सेक्शन 31 to section 36 as such. So in brief, this is all about the fundamentals of contract, formation of a contract, performance of a contract, and then discharge of a contract, then the remedies for breach of contract, contingent contract, and quasi contracts as such. So we have discussed all necessary elements required for valid contract. What kind of questions are asked? All contracts are agreements, but all agreements are not contracts. You have to define contract, define agreement. You have defined section 10 essential elements of a contract. Okay. If it is asked, what do you mean by free consent? Define consent. Define free consent. When consent is not free, define coercion, undue influence, fraud, misrepresentation, and mistake. And what are the consequences of these flaws on the nature of contract? It becomes voidable contract. By way of mistake by both the parties, it becomes void. Mistake of only one party with regard to price or with regard to law, then it becomes perfectly valid contract. Performance of contract, reciprocal performance, mutual and dependent, mutual and independent, that also we have discussed. Performance of joint promises also we have discussed. We have also discussed the certain provisions of quasi contract. We have also discussed certain provisions of contingent contract, and we have also discussed the when contract comes to an end, and we have also discussed the discharge of contract when contract comes to an end, and how and what kind of actions you will be taking in the court of law in case the other party commits breach of contract. I hope this entire 2 hours and 15 minutes must have given you, probably I would not say a new thing, but it must have refreshed your memories, because long back probably you must have learned the Indian Contract Act when you were there in the first year, and or maybe in the third year, those who have done 5 years course, and now you have somehow refreshed those memories. You can go back to the Bare Act, and when you try to understand them, I hope the understanding will become easier. And if that understanding becomes easier, I think the entire, I would say that the lecture would be some kind of a help to you. So thank you very much for attending this session and patiently listening this. I would like to thank the Bar Council of Maharashtra, Dr. Rajendra Bule, and all entire team who is present even today. And I would like to give best wishes to you all, and looking forward to see you in the other side of the bar, that is on the bench, and see to it that you will do justice to this examination, and you will do justice to the prospective litigants in the courts, and perform your duties with all volition and all virtues at your command. Thank you once again. If you have any difficulty, you can ask on the chat, or you can unmute if it is possible. Otherwise, from my side, I am concluding this. Thank you so much.
On behalf of Bar Council of Maharashtra and Goa, I express sincere thanks to Dr. Prakash Chaudhari for enlightening all basic concepts of general contract by giving an example of our day-to-day life, especially example of Ashwastama that will remember for the view of. Once again, I would like to thank Dr. Prakash Chaudhari for sparing his valuable time and giving guidance about the probable questions on general contract. I also thank all the participants for joining the lecture, and I am quite sure that this lecture will certainly help all the participants who are going to appear for mains of JMFC as well as their day-to-day practice. Thank you very much, sir.
Thank you. Thank you, everybody.
Thank you, sir. Thank you.